It is now 2:30 p.m. And we are live. Good afternoon, everyone. Thank you all for joining us for today's presentation. My name is Jaleesa with Legal Aid of North Carolina's Helpline. Today we have Lorena Evans presenting for us. If you are unfamiliar with the format of this event, Lorena is going to review a PowerPoint presentation. At the end of the presentation, we'll have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comment section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Lorena will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Lorena to get us started.
Awesome. Thank you, Jaleesa. Good afternoon, everybody. My name is Lorena Evans. I am a supervising attorney with Legal Aid of North Carolina's Second Chance Project. And today I'm here to share some legal information about criminal record expunctions. I will just mention right now, as Jaleesa said, I am an attorney, but I am not your attorney. And so I do welcome any questions, but I will ask that you keep them general. If there are questions that I believe are too specific to your own circumstances, I will skip over them. I would encourage you to reach out for legal aid assistance after this presentation to see if you may qualify for our services. If we're able to open a file for you, that would be the point at which an attorney will be able to give you more specific information and advice about your circumstances. But today, I'm just here to give you some overall legal information about expunctions. And so about Legal Aid of North Carolina generally. So Legal Aid of North Carolina is a statewide nonprofit law firm, and we provide free legal services for civil matters and criminal expunctions and driver's license restoration to low-income people. The goal is to ensure equal access to justice and to remove legal barriers to economic opportunity. And so Legal Aid of North Carolina is a civil law firm. The only criminal adjacent law matters that we handle are criminal record expunctions and driver's license restoration, which is what the Second Chance Project does at Legal Aid. Now, today we are here for a listen and learn about criminal record expunctions, but Legal Aid hosts a variety of listen and learns that cover many of the areas of law that we can assist with. And so along with this criminal record expunction, we have one for healthcare power of attorneys, wills, and advance directives, benefits such as Social Security, disability, SNAP, Medicaid. We have family law that covers simple divorce and child custody, and then tenants' rights as well. And so just as you may have done for this presentation today, you could sign up for any of the listen and learns that we provide on our website. And you can also watch previous recordings of listen and learns on our website as well as on our social media profiles as well. So all of that to say, let's jump into expunction specifically. And so I will start by saying that expunction law is state specific, meaning that we are only covering possible expunction eligibility and information as it relates to North Carolina charges and convictions. I'm also only a North Carolina licensed attorney, and so we are not able to provide any information about possible expunction eligibility as it may relate to out-of-state criminal charges as well as federal charges. And so only speaking and referencing expunction law as it relates and as it applies to North Carolina charges and convictions, meaning that they need to have occurred in the state of North Carolina. And so what is an expunction? Generally, expunction means to permanently remove an offense or a conviction from a criminal record. And so ultimately, the end result of an expunction is once that is granted by the court, the public record of that offense or conviction is destroyed. And I say public intentionally because as we get to the end of the presentation, I'm going to review that there are a couple of entities in North Carolina that can still see expunged records for specific purposes, but generally expunction removes the public criminal record of that expunged offense or conviction from view from the public. And so in all North Carolina courts, there are public terminals, usually outside of the clerk's office, where you, me, any layperson could go to the courthouse, type in your name, and pull up your North Carolina record. And so what an expunction would do is, once it is granted, it would remove those records from that public terminal. And so if you were to receive an expunction, if I was to go in the next day and search that case number or case numbers that were expunged in the database, they should no longer show up. And so that is, the goal and the end result of an expunction. So there are three primary types of expunction. We're going to go over them generally. There are many other expunction statutes, but these three types are by far the most common and what most North Carolina charges or convictions may fit under. And so I'm going to start with the most widely used, and then we're going to get into some of the more narrow types of relief. And so by far, what most individuals who have some type of criminal record are going to be eligible for are the expunction of not guilty and dismissed charges. So as it may be obvious that all charges where someone was found not guilty are eligible to be expunged. Additionally, the same goes for charges that were dismissed. Those are also eligible to be expunged. Now, with dismissed charges, most charges that are dismissed after December 1st, 2021 should be automatically expunged 6 months after that dismissal. Now, charges that were dismissed prior to that date are still eligible to be expunged. The individual would just need to fill out the paperwork, the petition, take it to the courthouse, and start the expunction process that way. But if somebody were to be charged with 2 offenses today, let's say, both of those offenses on that case number were dismissed, 6 months after that dismissal date, the system should automatically expunge those 2 dismissed charges as a matter of process. And so if somebody has not guilty or dismissed charges on their record, those are immediately eligible upon that disposition. There's no additional wait period or anything like that. If the charge was dismissed or you were found not guilty of that charge, as soon as the clerk goes in the database and types that in and enters it into the case, that individual could come to court or come to the courthouse the next day with that petition ready to file to begin that expunction process. Now, the other 2 types of expunction cover convictions, and we separate those out into 2 different types of convictions. We have what we refer to as youthful convictions, and then we also have adult convictions. So youthful convictions are most misdemeanor convictions and some Class H or I felony convictions that were committed before December 1st, 2019, when that individual was 16 or 17 years old at the time of the offense, may be eligible for expunction. And so prior to December 1st, 2019, many 16 or 17-year-olds who were charged with committing an offense, such as these misdemeanors and Class H or I felonies, were being prosecuted, or I'll say adjudicated in the adult justice system. And what that meant was that those records were public. And so December 1st, 2019, North Carolina raised the age of what I'll say maturity to 18, meaning that 16 and 17-year-olds after that date who were charged with committing some of those misdemeanors and Class H or I felony offenses would be adjudicated, would be prosecuted in juvenile court where the records are sealed. And so as a way to provide relief to those individuals who were 16 or 17 years old at the time of the offense, who were convicted of those offenses, as a way to provide them some relief since those records are public, the legislature created this type of expunction relief so that those individuals could seek the expunction of those specific convictions. It's called youthful convictions on the slide, but you may have also heard of it as raise the age relief. And so that is that type of expunction. Then what understandably most individuals are concerned about is possible expunction of adult convictions. So there are some misdemeanors and few felony convictions where someone was 18 years or older at the time of the offense may be eligible for expunction. Now, there are a lot of different moving parts in the law that speak to whether somebody's adult convictions may or may not be eligible for expunction. And I'm going to go over in the next slide one of the biggest issues when it comes to evaluating adult conviction eligibility, and that is essentially what could prevent someone from expunging their adult convictions. Now, expunction law is law, so when as an attorney, when I'm reviewing a criminal record, I look at the law, I look at the statute to direct me to see what somebody may or may not be eligible to expunge. And in the specific statute that speaks to adult convictions, which is on the slide right now, which is 15A-145.5, the very first thing in that statute is a list of offenses that the legislature has said are not eligible for expunction. And essentially what the law says is that if somebody has a conviction for any one of these alienated offenses in that list, they are not eligible to expunge any convictions that occurred when they were 18 years old or older. However, they may still be able to expunge convictions that occurred when they were 16 or 17 that may fall into that raise the age relief. They are also still eligible to expunge any dismissed or not guilty charges that they have. And so essentially, when evaluating expunction relief, the very first thing that I as an attorney would do would be look at the record as a whole and then see if there are any of these offenses that somebody may have as a conviction. So it matters if somebody was convicted of one of these offenses. If somebody was charged and it was dismissed or they were found not guilty, that does not impact the expunction eligibility for adult convictions. What matters is the conviction for that type of offense. So on the slide right now is a list of the most common ineligible offenses that we see. It's not the complete list. There are a couple that we left out because we rarely see those. I've been doing expunction work for 3 years, and there are some on that list that I've never seen. And so we cover the most common that we find that most people who have a disqualifying conviction often have one of these types. And so the first type is any Class A through G felony conviction. So common law robbery is a Class G. The sale of drugs, also a Class G felony. Somebody has a Class A through G felony, they're not eligible to expunge any adult convictions on their record. And it only takes one of these types of convictions to essentially prohibit somebody from expunging any of their adult convictions. So even if somebody only has one, and then every other conviction is not for any of these types of offenses, unfortunately, that one disqualifying ineligible offense conviction would stop that person from being able to expunge any of their adult convictions. Next on the list, we have Class A1 misdemeanors. So it can be misdemeanor child abuse. We have domestic violence protective order violations are also Class A1 misdemeanors. Any convictions that require sex offender registration, those are disqualifying. Assault offenses, the easiest way to spot if an offense is an assault offense is if it has the word assault in the name of the offense. That's a pretty big indicator. So we have the example on the screen: assault on a female, simple assault, assault with a deadly weapon, anything that has assault in the name. If somebody has a conviction for one of those types, disqualifies them from expunging their adult convictions. We also have any felony offense that involves heroin or methamphetamines, and this can be just mere possession of heroin or methamphetamines, which differs from the last bullet point, which is possession with intent to sell or deliver cocaine, or as we abbreviate it to be PWISD cocaine, which is different from the heroin and crystal meth because mere felony possession of cocaine is not disqualifying. For cocaine, there needs to be some kind of further intent to sell or deliver, or actually sell or actually deliver, whereas with heroin and methamphetamines, the mere possession of those types of drugs is disqualifying. So it's a lot of information on the slide, but essentially the takeaway is that if somebody has a conviction for any of the what we refer to as disqualifying offenses that are in that alienated list in the law, it makes them unable to expunge any of their adult convictions. Still eligible for any raise their age or youthful conviction relief if they have any, as well as expunging their dismissed or not guilty charges. But if somebody were to pursue that and expunge their dismissals or not guilties, or any raise their age eligibility that they may have, ultimately, if all of those petitions were granted, that individual would still have their adult convictions remain on their record. Now, gone through the law, very broad overview of the law. Now I want to walk through a little bit about the process generally. The expunction process for any type of expunction, whether it's dismissal, not guilty, youthful convictions, adult convictions, tends to follow the exact same process. What I will say is this process can vary in terms of time, length, how long it can take. It really does depend on the county in which you're filing expunction petitions. And so what I mean by that is, in order to expunge any eligible charges that somebody may have, they would need to file petitions in the county in which those charges occurred. And so if somebody had charges in Wake, Johnston, and Moore counties, let's say, and they had dismissed charges in all of those counties, that person is at least filing 3 different petitions, because you would have to file a petition for the Wake County dismissals, for the Johnston County dismissals, as well as for the Moore County dismissals. You would also have to file separate petitions, even in the same county, if somebody had district court charges that were dismissed, and if they had superior court charges that were dismissed. And so this process can get lengthy, you know, depending on how long somebody's criminal record may be. If somebody has charges that span multiple counties, you can see how easily it can be for the number of petitions to pile up quickly, depending on the type of relief that someone's eligible for. But all of that to say, the process should be the same and should follow the same steps, no matter how many petitions that you file or how many counties that you may file in. And so the first thing, arguably the most important thing, would be to obtain an accurate and complete copy of the criminal record. You're going to want it to be accurate and you're going to want it to be complete, because that is the only way that you would be able to accurately determine what somebody may or may not be eligible to expunge. And so in North Carolina, there are at least 3 databases that house public criminal record information. And so we at Legal Aid, if we are reviewing a client's record, we're pulling from at least those 3 public databases. It will soon just be 2, but the North Carolina Department of Adult Corrections keeps their own database. We have Cypress, which is the database that is slowly phasing out of all of the counties. And then we have the portal database, which is becoming the new statewide database that is rolling out into all of the counties. And we search those 3 to hopefully obtain an accurate and complete record for the individual. Once you have that complete record, next step is to determine the eligibility for the expunction. So as I gave an example earlier, as an attorney, what I do is look at the criminal record and essentially plug that person's record into the statutes to determine the extent of their eligibility. So we're looking at the adult conviction statute. Do they have any of these disqualifying? Do they have any raise the age eligibility? Do they have any dismissals? Do they have any not guilties? That is the second step once you have that complete record. If we were to open a file for an individual and they were to become a client, before we do this, we're going to call that person and confirm the record with them, because we want to make sure if we've missed anything that we find it. If there's something that we have pulled that doesn't belong to the client, we want to make sure we exclude that. We just want to make sure that they have told us that what we have reviewed is complete before we determine that eligibility. But once that person has determined eligibility, you're looking at, okay, might be eligible for dismissed charges or not guilty charges. We're going to identify the correct form. So expunction is a petition-based process, meaning that there is a petition form for each type of expunction relief. And these are standard forms that anybody can find and pull off the North Carolina court website and fill those out. They're all very standard and all look the same, except there's some information that varies depending on the type of expunction. But overall, the forms are standard. Want to use that form, complete it as the next steps suggest, with all of the information that is needed, And for some other types of expunction relief, mainly when it comes to convictions, whether it's youthful or adult convictions, there are some additional supporting documents required by law, by the statute, to be filed alongside those types of expunctions. So if somebody is seeking that type of expunction, they're going to want to make sure that those supporting documents are also completed. Let's say somebody has come to this step, they have all of the petitions that they are ready to file in all of the counties where they need to file them. The next step is to go to that county to file them. And so as a pro se individual, that just means as someone who would be filing their petitions on their own behalf. You can just go to that courthouse. If you had petitions in Pitt County, just go to the Pitt County courthouse and file the petitions with the clerk's office. And they would take it, they would file it, and they would put it in the system ready to be reviewed. Me as an attorney, we have to electronically file our paperwork. And so if I'm filing the petitions for a client, I would file it online and send it electronically to that clerk's office for them to file that way. Once somebody has filed all of the petitions, what happens next usually varies county by county. What that means is some counties, some judges might require a hearing on the petitions. If there's a hearing, the clerk should send notice to that individual or the attorney if they're represented, letting them know that that petition was scheduled for a hearing on X date. That tends to be the case for conviction petitions. So if somebody is seeking the expunction of any convictions they have, that tends to be where hearings may come up. For dismissed and not guilty charges, those petitions are often signed by a judge at their desk in their chambers and don't often require a hearing. But that is up to the judge's discretion. And so ultimately, if there is a hearing, that individual or attorney should attend. If there's not a hearing and the judge reviews it and hopefully grants it, then what the clerk should do is once they have executed the expunction, meaning that if the judge grants it, they have signed to certify that they have removed those charges or convictions from their database. What they will then do is mail a copy of that order to the address that the individual put on the form. If somebody is represented, usually they will send that form, that order, to the attorney listed on the form. But ultimately, the expunction order is the exact same form that was filed, just with the judge's signature on the back, either granting the expunction or denying the expunction. If the expunction is denied, the judge has a space to list out why they have denied it, but hopefully the end result is that their petition is granted. Once somebody has received that order back from the clerk, showing that the judge signed and granted it, as well as the clerk signed to certify that they executed it, the last step will be just to verify that the clerk has done that. And the way that you can do this, or the way that someone can do this, is go to those public terminals in the courthouse. Doesn't matter which courthouse, because the database searches statewide. So even if you're in a different county to where the petition came from, that doesn't matter. Go to the public terminal, type in the case numbers that are on that form. If clerk executed it accurately, none of those expunged case numbers should show up in the database anymore. And so that is overall the process of expunction in North Carolina. Like I mentioned, no matter what type of expunction you're filing or where you're filing, this is likely going to be the process in which that expunction is reviewed from beginning to end. And so last slide is, like I mentioned previously, where I'll talk a little bit about entities in North Carolina that can still access expunged records for very specific purposes. And so prosecutors, aka district attorneys offices, they can access expunged convictions for sentencing calculations or habitual offender status. And so what I mean by that is if somebody were to seek the expunction of their convictions and they are subsequently charged with a different offense in the future, if they were to plead guilty or be found guilty of that subsequent offense, the DA, the prosecutors can use those expunged convictions and have access to those expunged convictions on that person's record when it comes to them determining the sentencing range for that subsequent offense or if that person should be considered a habitual offender based on those records. And so those can be seen and can be used by district attorneys in that way. Additionally, arresting agencies keep what we refer to as investigative records. And so they are not required to remove expunged cases from their investigative records. And the main reason for that is their databases aren't public. So me, you, anybody that doesn't work at an arresting agency doesn't have access to the information and the database that they use. We have found that arresting agencies are beginning to start removing expunged cases if they receive notice of the expunction. And so on the expunction form, there are boxes where you can put the mailing address of the arresting agencies, the law enforcement agencies, the sheriff's department, and the clerk is supposed to send copies of the order once the expunction is hopefully granted to those agencies listed. And so that can be a way, and they are beginning to, even though they're not required to, delete those expunged records. And so they can still see them, but they can also remove them if they receive the order to remove them from their database. And then lastly, we have law enforcement agencies. They can see expunged records when it comes to employment and certification purposes. And so if somebody who received an expunction wants to work in law enforcement, they can see those for employment purposes, and they can also see them if somebody who is looking to seek some kind of certification, they can also see expunged records for those purposes as well. Overarching, these databases aren't public. However, they can only see them for those specific purposes. And expunction is really to remove the public record of those offenses or convictions if they are expunged, to hopefully be able to assist individuals with moving on and, seeking better employment, housing opportunities, whatever the case may be. And so that's all I have today in terms of expunction, but that is our website listed on the screen right now, our helpline number. We are currently doing intake for new clients the first full week of every month. And so the intake week for this month is actually this week. It started yesterday. And so if you are interested to see if you qualify for legal aid services, to see if we may be able to open a file for you, I would encourage you to call that number sometime this week. And we are opening up to 40 cases a month. We have a very small but mighty team. And so we understand that there is a big demand for our services, but we want to make sure that our clients receive the best service that we can provide. And so we do limit the intake, but I will say if you're not able to get in this month, that we will be opening intake again for September. And so you can check on the website listed on the screen to see what week that will be. And I would encourage you to call back at that time as well. And so I'm open for questions now.
And now we're going to open it up for questions. For anyone with their hand raised, please be aware that you can't unmute in this forum, and you would need to type your question in the Q&A box on Zoom or the comment section on Facebook. Please remember we can only answer general questions. And so it looks like our first question is, are you able to expunge convictions?
Yes. Now it depends on what type of conviction it is, what it was for, how long ago it was. There are many different factors that I didn't get into today, just because it gets complicated very quickly. But ultimately, yes, there is a possibility that somebody may be eligible to expunge their convictions, but it's hard to say without looking at a complete record, of course, because there are a lot of moving parts and there are things that could determine whether somebody is or is not eligible. But generally, yes, somebody may be able to expunge their convictions depending on what type of convictions they are.
Okay, so it looks like the next question is, can Schedule II substances be expunged, the possession with intent to distribute?
That is a bit too specific of a question for me to answer, just because I'd have to look into that a little more because it depends. So I'm not really able to say.
Okay. So the next question is, can charges received at the age of 17 be expunged?
That I think that would depend on when they were. I would say if they were probably prior to December 1st, 2019, then they're likely public. And if so, then yes, they would be eligible to be expunged. If the records are sealed and somebody was prosecuted in the juvenile justice system, then I can't speak to that possibility. But if they're on the public criminal record for that individual, and if they were likely charged before December 1st, 2019, then they likely would appear. And so if they were dismissed or someone was found not guilty of those, then they could possibly be expunged, yes.
Okay, so the next question is if an assault charge is a misdemeanor, are you not eligible for an expunction?
What is the determining factor for that kind of conviction is the assault part. So that is what is going to determine whether it is disqualifying, not whether it was a misdemeanor or a felony. And so if somebody has a conviction for assault on a female, simple assault, unfortunately, that's likely going to disqualify them from expunging any convictions, even if it was a misdemeanor versus a felony level assault.
Okay, so the next question is an adult conviction of misdemeanor class 1 eligible for expunction?
The only disqualifying, it depends. It's going to depend. I can't necessarily say that as a blanket statement because there are many different moving parts, so it would depend. Class A1 misdemeanors are the only misdemeanor class that is generally disqualifying, but just because something is a class 1 misdemeanor doesn't automatically make it eligible. So it would depend.
Okay. The next question here is what is the overall cost one should expect through this expunction process?
That is a great question. And so if somebody is filing an expunction petition for expunging not guilty or dismissed charges, generally there is no cost. And so there's no filing fee to file those types of expunctions. There would be a filing fee only if someone was seeking the expunction of dismissals that were due to some kind of deferred prosecution agreement. And so, for example, if somebody were to be charged with some offense, the DA said, go on 12 months of probation. If you can complete it successfully, we'll dismiss those charges. Or if it was a drug offense, complete this class. If you complete it successfully, we'll dismiss the charges. Even though those charges were ultimately dismissed, there is a filing fee, and that filing fee would be $175. Additionally, if you file for the expunction of adult convictions, that filing fee is also $175 for every petition that you need to file. For youthful convictions, the filing fee is $52.50. All of that to say, there is a form that anybody can file along with their expunction petitions that's known as a petition to proceed as indigent. And essentially, this form allows the clerk or the judge to deem an individual indigent, meaning that they are unable to front the costs of the filing fee, but that should not prohibit them from proceeding and filing the paperwork. And so if somebody is a client of legal aid, we can file that petition to proceed as indigent on their behalf. And the fact that they are a client of legal aid is almost always enough for the clerk or the judge to deem that person indigent, and we can get the filing fee waived. Even if somebody is not represented, they can still file that indigency form. Sometimes the clerk might just want a detailed breakdown of that person's income and something like that to support the proposition that that person can't afford to pay the filing fee. And so it's going to depend on how many petitions, what types of petitions, and things like that. But if somebody is able to become a client of legal aid and there are filing fees, we can almost always get those waived.
Okay, one moment. The next question is, can you expunge unemployment overpayments?
I do not believe so. I have never seen something like that or sought the expunction of something like that. So I don't believe so.
Okay, one moment.
Sure. I'm not 100% certain on that, but I'm not. I don't believe so, but I'm not 100% sure.
The next question is, would one be required to present in the courtroom in the case of an expungement that required a hearing?
That is going to depend on the court and the county. A lot of times, even as an attorney, I will go for a hearing, and a lot of times it's just the judge walking through the expunction and having questions about what the person is seeking an expunction for. And so I say a hearing, but it's really just a lot of times the judge just is like, are these dismissed charges? Yes. And that kind of thing. And so there might be a possibility that the judge has questions regarding the expunction, but it's not like a full-on hearing that some might anticipate or expect from other types of cases. But it really does depend on what county and the judge, honestly.
Okay, and our last question here is, can you receive more than one expungement, or how many charges can be expunged at one time?
Yes. Great question. For dismissals and not guilties, an individual can file as many expunction petitions as they need indefinitely. There's not a limit to the amount of expunctions that someone can get regarding their dismissals or not guilties. The same goes for youthful convictions. So if somebody has a number of youthful convictions, they can file as many petitions as they need to expunge as many of those types of convictions that they have. The only kind of limit on the number of expunctions that you can get is when it comes to expunging adult convictions. We kind of refer to it as like you have one bite at the apple. And so an individual would need to make sure that all of their adult convictions are eligible before seeking the expunction, because there is a time limit once the first petition is filed. All of the petitions that are seeking the expunction of adult convictions need to be filed within 120 days of each other. And so essentially want to make sure that all of the adult convictions are eligible, because if one is left out, for example, and someone seeks the expunction and it's granted, they would not be able to file a subsequent expunction to get that other misdemeanor, let's say, expunged because they missed it on the first go. And so that's the only type of expunction where there is a limit to how many times you can file. And in terms of misdemeanors, there's an indefinite number of misdemeanors that someone can get removed if they are all eligible, but somebody can only seek the expunction of up to 3 felony convictions. And so it gets quite complicated very quickly, but ultimately the only type of relief that has a kind of definite number of times someone can seek, and the amount would be for adult convictions.
For presenting. If you would like to review anything we talked about today, we have posted the recording of today's event to our Facebook. It will be immediately available. You can access this with or without a Facebook account at www.facebook.com/legalaidnc. You can also access this recording next week on our YouTube page at www.youtube.com/@legalaidnc/playlists and select the Listen and Learn playlist. If you would like to register for one of our other Listen and Learn presentations, such as child custody, tenant rights, or Medicaid, you can do so on our website, legalaidnc.org/clinics. Have a great day, everyone.
Thank you.